Hi, I have somebody who signed in named iPhone. I just need to get your name, and Jacob Suarez, I've got your name already. Hello?
Hi there, sorry, I was just out. Were you
I got you, Jacob Suarez. Thank you. But somebody else named iPhone signed in, and if I need your name to sign you in. iPhone. I'm going to send iPhone a message. Let's see. Okay. All right, I got you, Miss Hernandez. I'm trying to identify somebody named iPhone. I'm sending them a chat right now. iPhone, what's your name? All right, I see the cell phone camera was pointed to the ceiling. Oh, now you shut off the video. iPhone.
To Marcus Shaw.
To Marcus Shaw. Okay. Thank you. I got the 3 of y'all checked in. Thank you.
don't know. Mm. Mm.
Mr. Vivek, who are you here for?
I'm here for Mr. Frank Ryan.
Wow. All right, thank you.
Mm.
Get up here. Get up there. Get off me. Go up. Come on, get up here. Jason. Want to run around? Come on. Take a stand. Yeah. Sit down. This one. I got some drip. You know, anybody want it? Yeah, nigga. Ice cream, nigga. Snow cones, nigga. Frosted flakes, nigga. Nah. All right.
Oh, no kidding.
Let me ask. I have somebody who just signed in named Aaron Marshall. I don't have you on the docket.
Oh, really? I got an email saying this was the time for the Zoom court meeting.
And okay, and your name is Aaron Marshall?
Yeah.
I guess I already checked you in. Let me see. There's somebody else who appeared.
Oh yeah, but that's like a.
Okay, let's do it. Okay.
Okay, and Debbie.
Serious bodily injury, either several things. I have somebody signed in with the first name of Michelle and no last name. Who are you here for?
I do apologize. I am here for David Barnett. I'm sitting in on behalf of Janice Eggleston. She should be logging on in just a moment.
Okay, thank you.
Yes, ma'am.
My client, Mr. Ryan, is having some trouble with getting into the Zoom link.
Okay. I'm trying to, who are you here for?
Judge, I'm here for Carol Troberman for the Singh matter.
Oh, okay. Sing.
Edwin Singh.
24.
Okay, yeah. Oh, Edmund's, what's his
Edwin?
name? Edwin Singh signed in. So, okay, so I both have attorney and client signing in. Okay.
And is that the policy for your Zoom settings to have the client appear as well? I just want to make sure for future reference.
Well,
Because I usually,
this, I guess if everybody's paying attention, this may be the last time we are able to hold a Zoom hearing. And this is just an arraignment hearing. So clients, if you have an attorney, you don't need to appear for an arraignment hearing, but this may be our last Zoom meeting. So if for any reason anybody's cases need to be reset, you will potentially have to come back in person.
and at that time, will the client have to appear for an arraignment or only pretrial settings or no settings?
The client only has to appear for trials. So,
That's what I thought. Okay.
all right.
Since that's the case, do you think it would be okay if my client's excused just so that he doesn't have to miss any work or anything like that?
Yeah, definitely.
Okay. I don't know if he's here in the Zoom room, but
He's in the Zoom room.
Mr. Singh, can you hear me?
I'm here, yes.
Okay, yeah, I don't know if you saw that email string. I think there might have been a miscommunication with our paralegal about the need for your attendance. You're happy to hang, we're happy to, I guess, have you hang on the Zoom if that's okay with the court, but you definitely don't have to be on the Zoom, and we can chat when the Zoom is finished if you like.
Okay. Yeah, whatever's needed, that's fine.
Well, your presence is definitely not needed, so how about we just touch base as soon as the session is over, okay?
Okay, thank you.
Sure thing. I'll call you shortly. Bye-bye.
Yeah. All right, we're gonna call the docket. Thanks.
Good afternoon, ladies and gentlemen. Welcome to Georgetown Municipal Court. My name is Randy Stump, and I'm the municipal judge for the city of Georgetown. The reason we have asked you to be here, this is our Zoom arraignment docket scheduled for 1:30 on February 22nd. In just a moment, I'm going to call a list of names in alphabetical order. First, I just need to check and make sure who is here and who is not. And then secondly, we also need to know if what your plea is, if any, to the charge against you. Choices today are guilty, no contest, not guilty. If you refuse to enter a plea or do not enter one, I'll enter a not guilty plea on your behalf. Also, we need to know to whom you wish to speak today about your case. The choice is going to be the judge, the clerk, or the prosecutor. As most of you know, most people want to speak to the prosecutor first to see if they can work out some type of arrangement before we ever get to trial or anything else. And if that's the case, today's the day to do it. The prosecutor's the person to talk to. Please also understand, however, he does not represent you. He represents the people of the state of Texas. Anything you tell him can and may be used against you in subsequent trial if it ever comes to it. Anybody have any question about that before we begin?
No, sir.
No, Judge.
All right, let me go ahead and call the names then, and I'm going to apologize in advance if I mispronounce your name. Abdul Al Jumili.
Your Honor, counsel's present.
All right, sir. And plea on that one, sir, and to whom you wish to speak?
Not guilty, and to the prosecutor, please.
Not guilty and prosecutor. He'll call you up in just a moment. David Barnett.
Judge, my name is Michelle Colarusso. I am here on behalf of Janice Eggleston, who was originally retained to represent Mr. Barnett. We are here today to just present our motion to withdraw. The prosecutor stated that Mr. Barnett needed to appear and confirm that he in fact signed the withdrawal. And then we would be able to be off this matter and he can proceed with the hearing.
I understand. And Mr. Barnett, I see you're here as well. Is that correct?
Yes,
Yes, sir.
yes, I'm here too.
And let me ask, sir, do you have any objection to the attorney's withdrawal in your case?
To be honest, I didn't even remember I had an attorney on it. So yeah, I guess I signed it.
So, and you have no objection to their withdrawal?
No, I'll just talk. I would like to talk to the prosecutor.
All right, sir. Just need confirmation though that that your counsel is withdrawing. And counsel, if that's enough for me to hear your client consent, is that all you need?
That is, Your Honor. I have submitted over an order for your signature. So if when you get a moment, if you would be able to sign that for me, that would be all then.
I'll take a look at it as soon as I finish the docket.
You're amazing. Thank you, Judge.
Counsel, you're excused. Thank you for your
Thank you. Enjoy your day.
Mr. Barnett, you can certainly talk to the prosecutor and is that a not guilty and wish to talk to the prosecutor, or do you have another plea you wish to enter?
That's not guilty and wish to talk to the prosecutor.
All right, sir. He'll call you up here in just a few minutes.
Thank you.
Certainly. Jose Gutierrez Oliva. Is that Mr. Popper?
Judge, yeah, this is Mr. Popper.
Yes, sir.
Yeah, I'd like to talk to the prosecutor and work this out today, please.
All right, sir. And what's your plea? Guilty, no contest, not guilty?
Well, right now, not guilty, but I'll talk to the prosecutor and we'll probably change that once I work an arrangement out.
All right, sir. We'll put you down as not guilty and talk to the prosecutor. And that's on all the cases dealing with Jose Gutierrez Oliva.
Great. Thank you.
All right, sir.
Okay, bye-bye.
Thank you. Benina Gutierrez.
Yes, Your Honor, counsel is present. We'll be entering a plea of not guilty, and I would like to speak with the prosecutor.
So ordered. All right. Bianca Hernandez.
Yes, I'm present.
Yes.
My plea is no guilty, and I'd like to talk to the prosecutor.
Not guilty. Talk to the prosecutor. He'll call you up in just a minute.
Thank you.
Certainly. Jackie Inman.
I'm here.
Yes,
and
ma'am.
my plea is not guilty and wish to talk to the prosecutor.
Not guilty and prosecutor. He'll call you up in just a minute. And Ms. Inman, looks like you have several. Is that not guilty to all?
Yes. The only thing I kind of am not sure about is I lost the permit to move the vehicle, the 5-day permit to move the vehicle, because my car was actually stolen and that permit was inside of the vehicle. So I have like proof of everything else, just not that one.
I understand. Okay, so I'm putting you down. You have 3 charges and I'm putting you down as not guilty and talking to the prosecutor in all 3.
Okay, thank you.
Certainly.
Yes. Yes, sir.
Liu.
Today, we received from Wayne, Attorney Thomas Wayne, we received something about accepting an offer for defensive driving. So we received the license and the insurance and the offer accepting defensive driving via email.
Okay, so is understood. So we don't have a motion for continuance.
No, just accepting offer.
Mr. Swain usually could get that taken care of the case that was on the line to 370.
All right. So I guess we need to reset to the next available arraignment docket. What would the date on that be?
March 8th at 10.
All right. And that's Lou, L-U. Aaron Marshall.
Hey, I'm here. I am pleading not guilty and would like to talk to the prosecutor.
All right, sir. He'll call you up in just a moment.
Thank you.
Certainly. Stephen A. Oofade. Stephen A. Oofade. Recall all cases. Frank Ryan.
Appearing through,
Counsel, we just lose you.
Audio is going in and out. I'm appearing through counsel, appearance through counsel, Your Honor. I wish to talk to the prosecutor.
All right. And is this Mr. Ryan or is this
Mr. Ryan,
okay? it is
Your
Mr.
Honor.
Okay. And are you, so you're with counsel?
I am counsel.
Oh, you are counsel. I'm sorry. Excuse me.
Yes, Your Honor. Yes, Your Honor. Mr. Ryan is having some technical issues with the Zoom and everything, and we want to talk to the prosecutor before we, so we can hash out some.
So is that a not guilty and talk to the prosecutor then?
Yes, Your Honor.
Okay, he'll call you up in just a minute.
Okay.
Kurt Schubert. Kurt Schubert. Recall all cases. To Marquis Shaw. To Marquis Shaw.
Not guilty, and I would like to talk to the prosecutor.
Not guilty, prosecutor. He'll call you up in just a few minutes. Edwin Singh.
Judge, I'm present on this case. Would like to enter a plea of not guilty and speak with the prosecutor, please.
Not guilty, prosecutor. I'll call you up in just a minute.
Thank
Dominic
you.
Stewart. Mr. Stewart, I see your name on here. Can you hear me?
Yes, sir.
Yes, sir. And Mr. Stewart, what do you want to do about your case?
No contest and speak to the judge.
Okay. No contest and judge. Is that on all your cases, sir?
Yes, sir.
One, two. Angelica, how many of these do we have from Mr. Stewart? 6, you said? Okay, Mr. Stewart, and I'm just double checking here. It looks like you have 8 cases. So I've got you as no contest and talk to me in all. Is that correct?
Yes, sir.
All right, sir. I'll be with you in just a few minutes. Kenny Stubbs.
Good afternoon, Judge. Counsel's present.
Yes,
we previously entered a not guilty plea. I had filed a motion to compel discovery. I don't know if I need to continue to talk to the prosecutor about that or if it's just time to take it to you.
I have it. I don't know. I printed it out for you.
All right, sir. I'll tell you what I'm going to do. Let me go ahead and call the docket first, and then we'll come back to your case, okay?
Thank you, Judge.
Jacob Suarez.
Good afternoon, Your Honor. I'd like to plead guilty and talk to the prosecutor about defensive driving.
Guilty prosecutor and driving safety course. And are you eligible to take it, sir?
That's what I had questions about because I've never had a ticket or anything like that. I recently moved to Texas and I'm trying to get a Texas license, but all the DMVs are backed up for me. I was wondering if I could talk to them about that.
Yes, sir. I'll let you talk to him. So we're going to go ahead and put you down as a guilty and talk to the prosecutor.
All right. Thank you, Judge.
Colton Tyndale or Colton Tyndall. Colton Tyndall will recall all cases. I have Michael Hull. Is Mr. Hull here? Recall all cases. All right. So ladies and gentlemen, just to tell y'all, some of you know and some of you don't, the way this system works is that right now you're in a virtual courtroom on YouTube. So this is live on YouTube. In asking to speak to somebody, whether it's the judge or whether it's the prosecutor, typically we're going to take you into a private breakout room and allow you to speak with the prosecutor. I do want to tell you a couple of things, one of which is, please understand this is a real court proceeding. I am a real judge and the consequences here are real. So in saying that, I want to make sure that everybody understands that we certainly expect the conduct and language and other things to all be court appropriate. So folks, as far as I'm concerned, it's as if you were standing in front of me in open court. But anyway, so we expect you to be on your best behavior. Number two, we'll certainly let you know about the other when your time comes about transferring your case so that you can talk to them. But I do want to tell you, when you are finished in the private breakout room, you will note that there is a leave button. And if you hit the leave button there, you will have the opportunity to either leave the proceeding or leave the breakout room. I want you to leave that breakout room and come back to the open court proceeding here before you leave. We just need to make an announcement online about the disposition of your case before you're free to leave. Is everybody clear about that?
Yes, sir.
All right.
Yeah.
Anybody got any other questions before we proceed on to the next level? All right. If you'll bear with me, we're going to start calling people up, and those people that need to speak to me, I'll be with you in just a few minutes. So I got to tell you, Angelica, this is the weirdest doc that I've ever seen. And I'll tell you why. Because the first page printed on the first page, but it also printed on the back of the first page. So it's like I'm seeing double. And so Dominic Stewart, instead of 8, I counted 16.
I asked, oh, you know what happened, Judge? I wanted it to print 2 copies.
And it
but
did.
Instead of separating them, it like double-sided it.
It did.
Okay.
All right, so let's see here. There were just a couple of people that weren't here. Oa Fade.
I made them. Okay.
Kurt Schubert.
Now that one, now there's 2 attorneys who did not appear, and I think that was Schubert is going to be Michael Price, and he's not here. I haven't heard from him.
And Mr. Wilson, we're going to need to do, you've got a motion to compel. Have you had a chance to see it?
I have. On that.
Okay, we're going to need to have one today.
Yes. Didn't take that long.
Okay. Well, do you want to do that before you do all the rest of them? Because it'll be a while. Everybody's talking to you. Okay, we'll do.
That, depending on how old this is, one of the violation date is this pretty old. 2020. We did not start in getting police records to write assault by contact family violence until after Debbie started.
We have a complaint.
Do we have a complaint? That's a good question. Let me see.
And Fred, the other person that didn't show up was Colton Tyndall. So I think that's the only 2 that did show. That Mr. Swain didn't, but we reset his case.
Make sure you let them know that the link expires.
Mr. Shaw, Mr. Shaw,
Yes, sir.
Mr. Shaw, the state has made a motion to dismiss your case. You have any objection to that?
No, sir, I do not.
All right, sir. Well, I'll grant it. Your case is dismissed. You're free to go.
Yes, sir. I appreciate you.
You're welcome. Thank you.
Hello? I'm here on Mr. Oliva's case. Hello?
All right. Dominic, you can hear me okay?
Yes, sir.
Okay, so you've got 8 cases. 2 of them are failure to license the dog and cat. For those you pled no contest, and I'm going to accept your plea on both of those, and I'm going to find you guilty. And based on the information you've provided, I determine you're indigent and will allow 21 hours of community service within 30 days for the first offense, and 19 hours community service within 60 days for the second offense. The other 6 cases, I'm going to reset them all to March 22nd, 2023 at 10:30. Please understand that that's going to be in person because we're not going to be doing Zoom anymore to the best of my knowledge. Okay?
Yes, sir.
So any questions about that, sir?
No, say if I'm not able to appear, then, which I'm gonna try, but if I'm not, do I call the court ahead of time to let them know?
Yes, sir. Yes, sir. Mail us something that tells us what your circumstances are. You can you can send us an email if that's easier. If you can do that by your phone and tell us what your circumstances are.
Yes, sir.
All right, sir.
Yes, sir.
All right, sir. Thank you. With that, you're excused.
All right, thank you. Have a good day, Joe.
Andy? Yes,
Yes,
sir.
Your Honor.
So my understanding is you have 2 cases, and I believe the first one is the Al Jamili. Is that correct?
That is correct, Your Honor. And on that one, I did speak with the state, and we are going to be sending in a Morton discovery request, and prosecutors are going to be working on getting us video on that one. So if we could have a 30-day reset.
And that's what I'm going to do, sir. I'm going to go ahead and reset you to March 22nd, 2023 at 10:30.
Yes, Your Honor. And just and my understanding is our future settings are going to be in person then?
That's correct, sir, as far as I know. And on the Benina Gutierrez, that's the same with the same reset date?
Yes, Your Honor. We've been extended an offer from the state that I believe my client will accept, and we just need time to communicate that and get that taken care of.
All right, sir. So ordered. With that, you're free to go, sir. Thank you.
All right. May I be excused, Judge?
No, sir. Thank you again. Mr. Olafati?
Yes, Your Honor.
Yes, sir. Mr. Olafati, is there a reason why you're running late today?
Yes, Your Honor. We have a meeting that way above my control. I couldn't get out of it until now, Your Honor. I apologize about that.
Understood. So my understanding is you have a speeding ticket with us, sir, and I need to ask what your plea is to that charge.
No contest, Your Honor.
No contest. Would you like an opportunity to talk to the prosecutor?
Yes, Your Honor.
All right, sir. So ordered. I'll tell you what, if you'll bear with us, he's got a list of people he's talking to, but he'll add you to the list.
Thank you, sir.
Thank you.
Yeah, here's the Yankee one, which is a derivative, and there shows July 6th, mode date, demode date, July 4th, next in 2024. That's for 2 packs. And they have an alpha. Yeah, that's from my body then. Yeah.
Hello.
Hello, sir.
Hi. Yeah, I'm the attorney on Jose
Yes, sir.
Gutierrez Oliva.
Basically put 2 people on freaking for a year to work in. So then would I be under that?
Are you talking to me, sir?
What's your name?
Owo Fade.
Oh, no, I'm not.
Okay. Hello, ma'am. Can you hear me, ma'am?
That's the other aspect of it too is we're done November 1st, you can transfer, because we won't have any leave that happens for anything. So they can make the transfer effectively right away. That being said, they leave in July, and if, like he said, they're using a derivative. My last deployment, that's what we did too, they created a new line and then dumped everybody in the map.
Somebody is, we can hear whatever conversation is going on. Not sure who's not muted. Okay, that took care of it. Thank you.
I heard the judge. Still going. Huh? Still going.
All right, Mr. Vivek.
Yes, Your Honor.
Mr. Vivek and Mr. Ryan.
Yes, Your Honor. Your Honor, Mr. Ryan is having some trouble hearing the proceedings.
Understood. Not a problem. I just saw him in the virtual floor.
Excuse me. Your Honor, I'm able to hear you now.
Oh, good. Okay. Well, I just wanted to make sure. So, gentlemen, my understanding is, Mr. Ryan, on your case, that that was discharging a BB gun in the city limits. Is that correct, counsel?
Yes, Your Honor. It was a pellet gun, but yes.
Right. And so is your client then pleading no contest to that? Is that what
he's pleading? Yes, Your Honor. He's pleading nolo.
Okay, so I'm going to accept your plea, Mr. Ryan, of no contest, and find you guilty and assess the fine amount at $231, and you pay that within 30 days.
Okay, Your Honor, may I make a statement, please, sir?
Yes, sir.
I just wanted to note that this particular pellet gun, sir, was purchased in the 1960s, and it's nearly 60 years old. It's a collector's item, sir.
Yes, sir.
And it cannot fire. It makes a noise. It holds a CO2 cartridge. It makes a popping noise, sir, but it cannot actually fire.
Well, I guess the question is then, counsel, are you still wanting to do a plea arrangement on this, or is he providing controverting facts that would justify trial?
Mr. Ryan, would you like to withdraw your plea, or would you like to continue with the pleading no contest for the ordinance violation?
Your Honor, sirs, I don't want to prolong this to a trial, but I had hoped to be able to plead guilty to a lesser charge, something in the neighborhood of making a noise or something, or maybe public nuisance or something. I'm not aware of the law, but that was what I hoped.
I understand. I will tell you, if you want that, then your counsel may need to talk back to the prosecutor, because that really is more of a plea negotiation as opposed to what we're talking about here. So I have no objection if you want to get back on the prosecutor's list and talk to him about something else. And we'll just hold this until you make a decision on that, or we can proceed here. So your call on that, sir. Would you like to go?
Let me ask the advice of my counsel at this moment, sir.
All right, counsel. Let y'all talk.
Yes, Your Honor. Can we get a breakout room so we can sidebar?
Angelica, can you move them to a?
Take themselves off camera and call each other on the phone.
Yeah, the other thing you could do, of course, is just take yourselves off camera and call each other on the phone and talk to it. But we can try to put you in do we have any rooms available? Understood.
But I don't, but that's not included in the facts.
Mr. Suarez, Jacob. Jacob.
Look, there we go. Sorry.
Yes, sir. I just wanted to confirm on your, just a second. On your case that you said you were pleading guilty, sir. Is that correct?
Yes, and the prosecutor's given me, I believe, 60 days to.
Yes, sir. In fact, that's what I was just going to announce, that we're going to reset your case to April 26th, 2023 at 9 a.m. But please understand that is in person. We're not doing Zoom anymore. So April 26th, 2023 at 9 a.m.
I am allowed to submit, from what I'm understanding is I can just go and submit defensive driving after I've got my license, right? And I don't have to go to court?
Within that time frame, yes, sir, that's correct.
Okay. Awesome. Thank you.
Okay. So basically what that means is that you can sign up for DSC, but you have to have all the things. You have to have the $144. You have to have your proof of driver's license, proof of insurance. And I think there's an affidavit or something you're required to sign that says you haven't completed the course within the last year for the dismissal of a ticket. And if you do all those things, then yes, sir, you don't have to come back.
Okay. I'm curious, just a question to get the license. They asked for a proof of residence, and I'm not quite sure I approved that because I'm a student. I live like at my campus, and besides that, my parents live in Texas. Like, I don't really have any bills. How can I prove that?
You're asking the wrong person.
I'm
That's
sorry.
a yes question instead of a municipal court question. So I can't answer that.
Okay, my mistake. Sorry.
People have done it with electric bills and other things too, to show that you're receiving something at a particular location, but you'll have to ask them because I'm not sure what they'll deem to be sufficient. So is it okay to reset you for the 60 days? Are you okay with us resetting you for the 60?
Yes.
All right. And so with that, I'm going to go ahead and let you go, understanding that if you can get your driver's license and do all the other stuff within that 60-day period and come here to the court and provide that information, that they can do it for you or send it via email, however you need to do it.
All right. Thank you, Your Honor.
You're welcome. Thank you, sir.
Have a great day.
You too. Okay. And on the Singh case.
Yes, Judge, I'm present on that matter.
Yes, ma'am. So my understand on the Singh case, we're going to reset that one to March 22nd, 2023 at 10:30 a.m.
And is that an in-person setting?
Yes, ma'am. All the rest of our settings are going to be in person from here on out.
Okay, understood. Okay, sir. Thank you so much.
With that, you're free to go.
All right. Thank you.
Mr. Popper?
Yes, sir.
Mr. Popper, so my understanding on your counsel that your client has 3 cases, a failure to yield, a DWLI, and a no insurance. Is that right?
That's correct.
And your client then is pleading out on the DWLI and the insurance, and the state in consideration is asking for a reset for 1 year for the failure to yield.
What?
We
talked about dismissal. We didn't talk about a reset for failure to yield.
Hang on just a second.
Yeah.
That may be that he's just asking that as long as the other 2 get paid, if they get paid, that he dismisses it. And I think that's.
Well, I guess I'm on the rest of my life for this, so that's fine.
Give me just a second. Let me ask. Hang on.
Yeah. Okay, so your license is currently valid, but it's expired. So what I'm gonna do on that is.
So, Mr. Popper?
Yes, sir.
I've got a little clarification from the prosecutor. They're estimating that $100 a month, it's going to be roughly a year before he can pay those off. And he'll dismiss it as soon as they're paid off. If it comes into an income tax refund or something and can do it sooner, then the issue is he'll do it sooner. As soon as they're paid off, he'll dismiss it.
So can I ask a question? The fines are $331. Are the court costs another $200 or $300?
Yes, sir. Actually, state law requires that if you have a payment of more.
No, I'm not, Judge. I get that. My question is, if the fines are $662 and the state law requires an extra, little fee, what's going to take a year at $100 a month?
So we have, hang on just a second. Hold on just a second. So, just so you're clear, sir, so my understanding is that the costs were $81 and the fine amount was $250. So that's $331 a case plus an additional $15 for the going over 30 days that the
Yeah,
state.
no. So it's about $700.
Right.
Okay.
And
that's,
we're
I just wondering when you say it would take a year to do.
Not due until the first payment's not due until March. So
Okay.
the case that's roughly 10 months, but you know, if you want us to reset it 10 months, that'd be great.
Please just reset a year. Do whatever you want. Fine.
Okay. All right. So is that then what you want to do, or those things that I just announced?
Yes, sir. Yes, sir.
All right. So what we've got, sir, is your client's pleading guilty or no contest to both the DWLI and the no insurance. I'm going to accept those pleas, find them guilty, and assess the fine costs and the extra $15 at $346. So that's going to be what is that? A little under $700 total. At $100 a month starting next month. And then the failure to yield is going to be reset for a year, or again, if he pays them off sooner, if you let us know, then the prosecutors agreed to dismiss.
Okay, thanks, Judge.
All right, sir. With that, you're free to go.
Okay, bye-bye. Thank you.
Uh-huh.
Okay, I'm going to put you through just a little bit. I think
Your Honor, I am back and from negotiations.
So have you ever done community service before?
Okay. We will, do you need a reset or will he pay the fee?
He said that he was going to plead NOLO to the initial charge.
Okay. All right. All right. When the judge comes back in the room, I'll let him know. Okay. So he can talk to you.
Okay. Is there a way you can fix Mr. Ryan? I think what's happening, is there a way you can put him into a breakout room and then take him back out and see if that resets his connection, like his video and audio?
Right now.
So you want me to put him in another room and then bring him back in here?
Yeah, yes, ma'am.
Okay.
It's kind of odd what's happening.
I will try it.
All right, thank you.
7 days a week.
No, can't just use it.
I don't have any
But
rooms I can move him in right now. They're all being used.
That's fine. That's fine.
Okay.
This is where the parking ticket, so it's not.
Jackie, if you could accept the invitation to join a breakout room.
Unfortunately,
I don't see it.
Okay, I sent an invitation to join a breakout room.
So you need to pick and just tell me which one you want. And we'll make it work.
Somewhere on your screen, maybe you need to click on breakout rooms.
Doesn't show it. Oh, wait, I see it.
Ms. Hernandez, can you hear me?
Yes.
Okay, so Ms. Hernandez, you've been charged with a parking offense within 15 feet of fire hydrant. My understanding is that you pled no contest to that. Is that correct?
Yes.
Okay, so I'm going to accept your plea. I'm going to find you guilty. I have determined that you're eligible for community service, and I'm going to have you do 14 hours of community service within the 30-day period. We've talked about how you go, and if you go to Goodwill, for example, that they fill out the paper each time you go. You have to fill out your part, and then they sign their part. And when you get the 14 hours total done, you need to turn it in within 30 days here to Georgetown Municipal Court. Any questions about any of that?
No, sir.
Okay, well, thank you for your time, and with that, you're free to go.
Thank you. Have a good day.
You're welcome. You too. Let's see, counsel.
Your Honor, we have we tried discussing possible plea down, and the prosecutor said it's as low as he could go. So we're going to plead no. We're going to plead nolo contendere on this.
All right, sir.
Mr. Ryan, can you hear? Can you hear?
All right, and so my understanding is that Mr. Ryan, you are pleading guilty to the discharge of the pellet gun in the city limits. And in doing so, you're pleading no contest, is that correct? Can you hear me, Mr. Ryan? I don't think you can. I don't think you can hear me. Anyway, so counsel, your client's pleading no contest, is that correct?
Yes, Your Honor. If you'd like, I can get him on the phone right now.
If you make the announcement in open court, I'll trust you.
Yes, Your Honor.
So is he pleading no contest then?
He is pleading nolo contendere, Your Honor.
All right, sir. So I'm going to accept that plea. I'm going to find him guilty, and the fine amount is $231. Does he want to pay that today? Does he need 30 days to do it? What does he need?
He's going to do it sometime this week, but the 30 days will suffice.
Okay, so I'll go ahead and give him 30 days just to give him a little extra leeway.
Yes, Your
Any
Honor.
other questions, sir?
Yes, Your Honor. And Mr. Ryan also desires to pick up his the firearm that was in question. and the prosecutor agreed that he could get it back. So,
Okay, you need to hang on just a second. I need to confirm that because I'm not sure where it is. Is it with the PD?
I'm assuming, I'm unsure where it is.
So give me a second. Let me see if I can find out where.
Okay.
All right, gentlemen. So my understanding is that as soon as Mr. Ryan pays the citation, the $231, he can provide that receipt, take it down to Georgetown Police Department, which is off DB Wood Road. It's not anywhere near where we are, but he can go down DB Wood Road, and that's where apparently they're keeping the gun. And if he shows that to them, hopefully they will give him his firearm.
Okay. Can you provide a copy of the order as well?
Do you want that in the order itself that he's entitled to get his firearm back?
Please.
I can handwrite it if it's.
Please, Your Honor.
The problem is I don't really have any custody of that, but I have no problem if they have it, ask him to give it back to them.
Yes, Your Honor. We just want to be doubly sure.
I understand. All right, I'll do what I can.
All right.
Gentlemen,
Okay.
free to go.
All right. Are we, may we be excused?
You may. Thank you.
All right. Thank you, Your Honor.
Uh-huh.
All right. Bye-bye.
Okay, and Marshall's gone.
Okay, Ms. Inman? Ms. Inman, can you hear me?
Yes, I'm sorry. Yes, sir.
That's not a problem. Okay, so Ms. Inman, my understanding is you have 3 cases. The first one is a registration case and you're pleading no contest on that one. Is that correct?
Yes, yes, sir.
So I'm going to accept your plea. I'm going to find you guilty, assess the fine and cost is $184 to be paid within 30 days. Does that work for you?
Yes, sir.
Okay, now on the other 2 cases, are you pleading no contest or not guilty on those?
Not guilty. I am having 30 days to get my proof and they're resetting it.
Okay, so what I've got you doing is pleading not guilty on both of those. We're resetting both of them to March 22nd at 10:30 a.m.
All right. Thank you.
You're welcome.
So which one? From today?
With that, you're free to go.
Oh, Jason.
All right. Thank you so much.
Certainly.
Okay.
Mr. Barnett?
Okay.
Yes, Your Honor.
Barnett, 2 things on your case, sir. The first one is that we had the mini hearing to start with when the attorney that you had hired to represent you, I believe that was Ms. Colarusso, had filed a motion to withdraw, which you'd approved, and I just got your consent online to make sure that you'd approved her withdrawal. So I have granted her withdrawal, which allows you to speak to the prosecutor individually. Understood?
Yes, sir.
Okay, so we took care of that one. Now, on the second one, my understanding is you're pleading no contest to the offense of speeding. And the state has agreed to reduce or made a motion to reduce the amount of fine to $1 plus court costs.
Yes, sir.
So the total amount due would be $175.63.
Yes,
and
sir.
that will be due by March 24th, 2023.
Yes, Your Honor.
Okay. Questions about that, sir?
Yes, Your Honor. One question. If I pay that now and it's already like since 2015, do you know if those points are going to go on my license if I renew them? And is my license going to get suspended again?
I have no, you've got a Texas CDL, right?
I'm not even worried about the CDL anymore. I just want a driver's license.
Yeah, I wish I could tell you, but I don't know. I don't know the answer to that. That's really a tech stock question, and I'm not sure what they're going to do about that.
Okay, Your Honor. Thank you.
All right, sir. With that, you're free to go.
All right. Thank you, Your Honor. Have a nice day.
All right, sir.
Hanging out with the Army guy.
Yes, sir. Mr. Bradley?
I'm here, Judge.
Yes, sir.
All right.
Sorry, running a little late today.
I understand. I'm glad I made it back from the bathroom before you called me.
There you go. You have a motion to compel production of discovery in the Kenny Edward Stubbs case.
I do.
And you want to kind of summarize what you've got for us?
Mr. Stubbs is charged with obstructing a highway. He was driving a tractor trailer and he was at the point where he was about to back into the place where he was going to deliver this trailer. And he had a spotter out. They were doing things appropriately. and another driver came along and plowed into his trailer. I have information from the civil attorneys who are handling that side of it, that they have information that that driver was intoxicated. The fact that another car collided with him is really the only evidence of obstruction. If he was just out there on his own, he couldn't be obstructing traffic. And if the collision is evidence of the obstruction, then the cause of the collision is relevant. And if the collision occurred not because he was obstructing the highway, but because the other driver was driving too quickly, failed to stop because she was intoxicated, then that's relevant to the question of whether he was in fact obstructing the road.
Okay. Mr. Wilson, you want to respond to that?
Yes, sir. Let me pull. Give me a second here. I'm trying to find the statute, Your Honor. Because I don't even see that I've filed a complaint yet.
You sound muffled, Mr. Wilson.
I'm sorry, Judge.
Your voice sounds muffled.
Oh, that may be because well, I don't know why that is. I think it may be just because I'm down the bench from you.
There, that's a little better.
Okay. 1 second, Judge. No, it's not 4203 because that's a class B. Yeah, see, that was the issue, is we were trying to decide what the appropriate violation was. Okay, so let me explain to the court basically what I'm doing. My concern, Your Honor, is that I don't believe that the decedent's intoxication is either an element of the offense or a Michael Morton violation. The reason is that her actions in no way caused or contributed to what we are charging the defendant with. We're charging him with stopping in a roadway or obstructing a roadway. And whether she hit him or missed him or was intoxicated or not intoxicated is not, it doesn't go to any of the elements of the offense. And so that's why I'm concerned, and above and beyond that, I don't have access to this. I guess I could probably get it from the police department if necessary, even though I don't know if they have access to it. It may be something that the district, that who would have it? I don't know if any of us have it. And so the other issue is Mr. Bradley has told us that the only way he came into possession of this knowledge is because the civil attorneys gave him that information. And so if the civil attorneys have the information, isn't it just as easy for Mr. Bradley to get that information from them? Or is he asking for an order from, I don't think you can order the civil attorneys to turn over that information either.
I can answer a few of those things.
Sure, far away.
I believe the reason the civil attorneys can't give it to me, though this wasn't expressly laid out in our conversation, I believe they're subject to a protective order So they have the medical records and they can use them in their case, but they're prohibited from disseminating them to anyone else. Additionally, they're in Louisiana, so that would also raise an issue with asking them to do anything. Another point in the incident report here on page 5, it does mention that they have medical records related to the other driver. I suspect those medical records would include evidence of intoxication. But while there's a reference to medical records in the incident report, we were not provided with medical records. And that did not surprise me. They usually don't come over in the initial batch of discovery. And I'll add, if we need a protective order in this case, I have no objection to an order that just clarified that we can't disseminate that material, that it's only for use in this case.
Response?
Again, Judge, my concern is and I have to be honest with the court, I really don't care if you sign this order and say that the information needs to be turned over. I would prefer to have the signed order so that if somebody comes to me and says, why did you turn this information over? I can say I did it because the judge ordered me to do it. But again, the argument that I think needs to be considered is the decedent's intoxication either an element of the offense of what we're charging with the defendant with, okay? Or is it mitigating or exculpatory in any way? And I don't think that it is. I'd like to read the Texas Transportation Code, where it says an operator may not stop, park, or leave standing an attended or unattended vehicle on the main traveled part of a highway outside a business or residence district unless stopping, parking, or leaving the vehicle off the main traveled part of the highway is not practicable. A width of highway beside the vehicle is unobstructed and open for the passage of other vehicles, and the vehicle is in clear view for at least 200 feet in each direction on the highway. And again, the other statute we might proceed under is unsafe backing. But that's the problem is I'm not sure where I'm going with this right now. And I'm not sure how the decedent's intoxication figures into any of the elements of the traffic offenses or is mitigating or exculpatory.
So, counsel, let me just ask then, so does this, with the offense that your client is charged with, what bearing does it have on any of the elements of a stopped in a roadway and obstructing traffic? Trying to understand that.
The issue I've been focused on is whether he in fact obstructed traffic. And the language Mr. Wilson just read wasn't what I was expecting. So first, I think we need to figure out exactly what he's being charged with. The incident report references TRC 545.302. I don't know what Mr. Wilson was reading.
302 is stopping, standing, or parking prohibited in certain places.
Is that the statute you're?
Operator may not stop, stand, or park a vehicle on the roadway side of a vehicle stopped or parked at the edge or curb of the street, on a sidewalk, in an intersection, on a crosswalk, between a safety zone, blah, 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 on a bridge or other elevated structure.
So which of these subsections is the state proceeding under?
That's the question. Let me see.
Because looking at the statute as well.
Basically, we've been, to be honest, Judge, we've been holding off and resetting this because Mr. Bradley has asked me to, because the civil case is still pending. And so.
Is this a death case? Wrongful death case? Is that what the?
Civilly, Your Honor.
It's a wrongful death case. So the driver that ran into this died?
She did.
Okay. And where did this take place?
On the I-35 frontage road. It was northbound in that area where there's some car dealerships. It was about 2 o'clock or 3 o'clock in the morning.
somebody backing into one of those dealerships because they're kind of narrow roads there to have to get in. Is that what he was doing?
Correct. We also, we don't have a precise measurement of speed, and the sight line isn't clear because there wasn't a crash report that really laid this out. But I'll quote Officer Adcock, who described the other driver as hauling ass over the hill and then colliding with the trailer.
Okay.
See, and so if we charge him with unsafe backing, officer may not back the vehicle and operate unless the movement can be made safely and without interference with other traffic. To be honest, Judge, I don't know. You know, my argument is I can't see how the decedent's intoxication is either exculpatory or mitigating to the question of whether the defendant committed a traffic offense, whatever traffic offense it was. It's kind of like saying, okay, if I charge somebody with speeding, right, and then they hit somebody while they were speeding, and the other person was intoxicated, it doesn't matter whether the other person was intoxicated. The only issue is, was the defendant speeding? Did the defendant commit a traffic offense?
Here, we could potentially solve this just by starting with the preliminary question of, I mean, looking at this statute, I don't see any subsection that applies to the facts of this case. There's no sidewalk, there's no intersection, there's no crosswalk, no safety zone. He's not on a bridge, he's not in a tunnel, he's not on a railroad track. Looking at what's charged currently, I would ask for an offer of proof as to what facts the state could show that could prove any of these. I don't think there are any.
That's what I was noticing, Bradley, is we may be putting the cart before the horse because we have not filed a complaint yet.
Okay.
That the officer's ticket and the notice of what the officer wanted to file is the only thing holding us here right now. This may be a situation where I need to file a complaint and formally allege an offense, and then if the judge wants, you reurge your motion at that time. But so what I'm saying is, I don't think it matters what I charge him with, because the intoxication of the other person involved in an accident, which involves a traffic offense, as far as I can tell, is either not an element of the offense or is not mitigating or exculpatory in nature. Am I making that?
It's clear. I'll agree in part. I'll agree to the extent that until we know exactly what he's being charged with, we can't answer that question. So I would encourage the state to file a complaint and let's figure out exactly what he's being charged with.
Let me ask you, how long?
There may not be elements to support it.
How long will it take the state to be able to file a complaint? 30 days?
I should have it done within a week, Judge.
I know that there's going to be 1 week we're missing in March, so it's going to kind of be a shorter month for us. Why don't we just go ahead and reset this 30 days? And if you're able to do it prior to that time, that's great. And if counsel, if you want to file something based on that, a motion to quash or whatever you want to do, we can certainly proceed down those realms. But right now, I think I agree. I think it's a little bit premature until we know exactly what's being charged. And it sounds like to me that it's a little more of an open field than I realized.
Yeah.
So, if you don't mind, I'll go ahead and reset this for 30 days and ask the state to file a complaint within that time. And if it is done sooner than later, and counsel, you wish to respond, re-urge your motion, then we can certainly do that.
All right. Thank you, Judge.
Mr. Bradley, if I can ask you a question, do you
Certainly.
tell us how far along the civil case is?
I don't have a recent update to know.
Okay.
It was ongoing as of 6 or so weeks ago, but I wasn't given a good timeline for when they would be finished.
Okay. All right, well, I'll get something filed and we can come back and make the arguments.
Okay.
All right, Jim. Yep.
All right.
Bradley, your
Thank you.
excuse. We're
Thank
going to reset this case and let me get a reset date. Angelica, we got a reset date? 30 days.
March 22nd at 10:30.
Okay, we're going to reset to March 22nd at 10:30.
And this one will be in person?
Yes, sir, it will be.
All right, I will be there.
All righty. And with that, Mr. Bradley, you're excused. Thank you for joining us today.
All right, thank you, Judge.
You're welcome.
All right, the last one I have is Stephen. You already signed up for DSC. We already paid the 144. We already paid the 170. We now have.
This is Mr. Olafati.
Yeah, until May 23rd. Okay, I'll just get on here and talk to him.
All right, sir. So, Mr. Olafati, let me make sure I understand. So you're pleading no contest, is that right?
That's right, sir.
And so we're just going to reset him, allow him to, when he finishes the rest of the deal, so he doesn't have to show up.
Yes, I sent you some paperwork to your email address. You have until May 23rd to take the 6-hour driving safety course. Get us the certificate of completion and sign it.
Okay.
Get the affidavit notarized
Okay.
and turn it into us, and also information on how to get your driving record from the state.
Okay.
So with the affidavit, we do need the original copy, so that cannot be emailed in.
Okay.
But with the driving record from the state and the certificate of completion of the class, we do accept those email.
Okay.
But for the certificate, you do need to sign it before you email it to us.
Okay.
Okay?
All right, man.
So the completion date setting here is is May 21st?
May 23.
23rd.
Yes, sir.
At what time?
By 5, we need to have it done.
Okay, so by May 23rd at 5 p.m.
Yes, sir.
You're to have completed the DSC. And file with the court.
Okay, sir.
The certificate of completion. And if he does not do that, do we have a return date?
It's going to be a show cause hearing.
We already have a date, or we're just going to say it'll be show cause?
No, we're not gonna-
Okay.
it's a show cause.
All right. So Mr. Olafati, that it sounds like to me you're pleading no contest, and all I'm going to do is I'm going to reset you to May 23rd, 2023 at 5 p.m. to take and complete a 6-hour state-approved driving safety course, and also get a copy of your driving record, and they can tell you how to do that, and file by that date and time, got the original certificate of completion back to us, and the 3A driving record is required by law.
Yes, sir.
Questions?
No, sir.
All right, sir.
All right, thank you.
Bye-bye. All right.
All right. Bye-bye.
Free to go. Anybody else?